My name is Tonya Ford, and I live in Lincoln, Nebraska. I would like to start off by saying thank you so much for this opportunity. It is a great honor to sit here and represent my family and other families who have lost their loved ones due to preventable work-related accident. I support the Protect American Workers Act because of what happened on January 29, 2009, when I lost my Uncle Robert Fitch, or as I called him, Uncle Bobby, to a horrible preventable work-related accident at the Archer Daniels Midland plant in Lincoln, Nebraska. My Uncle Bobby was 51 years old. Our lives changed forever that day when my uncle stepped onto a belt-operated man lift in order to go to his work break, fell approximately 40 feet. As he fell, he impacted each wall in the cement elevator shaft and landed on the air duct, hitting it so hard it slid 19 feet from the connection point. At that point, my uncle slid off and fell through a manhole and then fell another 40 feet to the cement ground below. My dad, Uncle Bobby's brother-in-law, found him that day. My dad still works at this ADM plant. Since that moment, my life has become filled with gathering dates, statistics, evidence, and information. I started my research to answer our family's simple questions. What happened? Did he suffer? Did the device malfunction? Was the device too old and unsafe for my uncle and other employees that work at ADM? Something went terribly wrong that day, and my cousin Jessica and Jeremy Fitch, my mom, and the rest of our family deserve to know what happened and why. I have come to the conclusion that if POWA had been passed when it was first introduced, my uncle might be alive 3 weeks ago to place a rose on his mother's casket. Instead, when my grandmother passed away last month, we placed a single rose on an empty chair where he should have sat. POWA is important not only because it included tougher penalties to discourage companies letting safety problems continue, but because it extended additional rights to family members. If POWA had been in place when my uncle died, my family would not have learned about the fines assessed against ADM from a local news reporter. When the television camera rolling, the reporter asked me, "What do you think about the penalties assessed by ADM?" I could only respond, we are not aware what the penalty is, and that the investigation was even closed. This is how our family learned that ADM was fined $0 for having an old and dangerous belt-operated man lift in their plant. This piece of equipment caused my uncle's death, and that I have since been informed it is inherently unsafe and very scary to use. A device that you should require specialized training before anyone should use it, and a device that causes many injuries and even deaths. Yet ADM received no monetary penalties for having this deadly equipment in their plant. We asked, why was ADM not fined from OSHA for the device that took my uncle from us? 9 months after hearing about 0 penalties assessed at ADM, my family still did not have the answers. I reached out to OSHA for answers in January 2010, and OSHA agreed to meet with us. I was ready to ask them all the questions that resulted in my months of research in belt-operated man lifts. To my amazement, I learned that OSHA issued 2 citations to ADM that were classified as serious and specifically related to the dangerous belt-operated man lift. However, as part of the informal settlement between OSHA and ADM, the 2 citations related to the man lift and the monetary penalties were deleted. When we asked why OSHA told us that these dangerous man lifts were not covered by an OSHA standard, under an OSHA standard issued in 1971, man lifts installed prior to August 1971 were grandfathered in, meaning that OSHA standard did not apply to them. OSHA explained that because of this grandfather clause, they could not uphold the citation if ADM contested it, but through their settlement with the company, ADM agreed to replace the belt-operated man lift that killed my uncle with an elevator. OSHA thought this was a good compromise, getting ADM to get rid of a highly dangerous piece of equipment and install something safer in its place. That's not good enough, and here's why. This ADM facility where my uncle was killed and where my dad still works had a total of 5 of these belt-operated man lifts, stating that only had to replace just one of them does not get rid of the problem. These man lifts are operating in other ADM facilities across the country. This equipment kills workers. A company like ADM with a stock market value of $18.31 billion should be compelled to replace all of these dangerous lifts immediately. I urge Congress to pass the Protect American Workers Act because it would improve OSHA's ability to ensure workers are protected from dangers on jobs. I support the provision to increase OSHA's penalties and have been routinely adjusted for inflation, but penalties are only effective if OSHA has the ability to compel abatement, even if the employers contest the citation and penalties. The Federal Mine Safety Agency has the authority for the 300,000 workers it covers, and OSHA needs it for the 111 million workers who rely on its protection. As a family, We believe if we are going to prevent more deaths and hurt, OSHA must be able to force abatement during the contest period. We strongly support all the provision of POWO, including the new rights that would be given to family members. We believe it is very important for OSHA to meet with the family or the representative before the agency finishes its investigation, and for the family to have the opportunity to make a victim's impact statement if in the case proceeds to the Occupational Safety and Health Review Commission. My Uncle Bobby gave 32 years to ADM, often working 7 days a week. My dad still works there, as do many other men and women. This month alone, we've seen too much deaths and grief because of preventable workplace hazards. If companies do not set the bar high enough for workers' health and safety, then OSHA must be empowered to do so. Thank you.